Hello, fellow toolboxers. Welcome to episode 274 of the Immigration Lawyers Toolbox podcast. It's another fun one with our wonderful colleague, Kevin A. Gregg, who's got his own podcast, Immigration Review. And he comes over once a month to give us the best and happiest cases, if possible, when it comes to immigration. It's a very popular issue that we have of the podcast, and every month we do it. And so I'm glad he helps out and comes on board to help improve your practice, which is the point of everything we're doing here. It's a new year, and I've been kind of slow in getting a lot of content out. One is because we published the old magazine, not old, the previous one that just came out. Go to iltbox.com and click on the magazine tab for the newest issue of the Toolbox magazine. But also prepping for the conference that's coming up next month. And the lineup of speakers, some of the best O1 attorneys in the world are our speakers. We have Flavia Lloyd, we have David Malik Telfer, you have Ron Madden, and much more. And it's intimate, very, very, very small people. I mean, you're going to be touching you could not touch, but you grab all the speakers' hands that close. We're going to have dinner together. We're going to have lunch together. It's intended to be really personal, so you can become friends. That's the goal. So it's no one's done something like this. It's not cost effective to do something what I'm doing, but the goal, of what we're doing here is to make better immigration lawyers. So if you want to take advantage of a once in a lifetime opportunity to become a better practitioner, increase your what you do, help clients more, make more money in 2023, just send me an email at info@immigrationlawyerstoolbox.com or visit iltbox.com, click on the postgraduate training tab and do the contact us there. Only like 3 seats left, so take advantage of it before it runs out and jump into it. If you haven't already, leave a review wherever you're watching this, 5 stars, subscribe, do all that good stuff to help us going. And I do want to reference a new sponsor that we have. You probably know their name. The podcast, this episode, is sponsored by Serenade, a technology company that's been a leader in serving the immigration space for nearly 30 years. E-Immigration by Serenade is a modern practice management software for immigration attorneys and other legal professionals to manage their cases, clients, forms, billing, and much more all in one place. The software is trusted by tens of thousands of happy attorneys, and in 2022, it earned the highest rating for immigration software on both Capterra and G2 for best value and best ease of use, among other awards. Immigration has everything you'd want in a modern practice software. It's cloud-based, has a sleek, intuitive UI. That's how the design looks and everything, and bank-grade security, all with the knowledge and responsive technical support team that knows immigration. But what really separates the immigration from the pack is it's comprehensive across over 100 features. These include features you might not use today, but it can save you time tomorrow if you just jump on and learn them, like the e-filing system. Immigration is the only platform that offers e-filing for all USCIS forms. Stop paying for multiple software and use Immigration to handle all your practice needs. For a demo, visit serenade.com/immigration and note that Serenade is the C, not an S, serenade.com/immigration, and visit or reach out to sales@serenade.com for more information. So having said all that, I got the course, Marriage Green Card course. Email me if you're interested in that, but let's just jump into it. Just note this is not intended for individual legal guidance, so general kind of stuff. Don't you gotta get the lawyer disclaimer, but let's get the show started. Kevin, thanks for coming on the show again for our regular. Before we start, how's the rain in San Diego? Your LA's been pretty bad, but NorCal's supposed to be deadly.
It's rainy. It's really rainy. Our house, I think I'm gonna have to dig a hole and put some rocks in it and hope that because we're not ready for this. It just puddles up. So I don't know. I think it's good in the long term, but right now just everything is kind of cold and wet. I don't like it. It's not used to it in San Diego.
Yeah, I had to go on the roof and clean the gutters because I saw the water was pouring out. I'm like, oh no, it's clogged. So I had to go do that kind of stuff, do some handy stuff. But it's sunny right now, which is surprising how nice it is outside. But I guess the East Coast people are getting snowstorms and 5 feet of snow is kind of nuts, that situation.
Yeah, I did my 2.5 years in Boston. I know what this is like. I'm just not. I mean, I left for a reason. In Miami, It's always rainy. It's just kind of humid as well. I don't know. Every time it rains in San Diego, I'm kind of worried that I'm gonna find something new in the house. The houses aren't used to it. In Miami, you figure it can take a Category 5 hurricane, but.
Here, that roof is leaking. That's gonna be a headache to fix. That's a nightmare always. Well, what's going on in the immigration court area? What's popping?
Well, the circuits are active as always. They were a bit quieter in December, and actually there were a lot of losses for non-citizens. But in January, for our talk next month, it'll be a bit better because there's been more wins. And I like to come on your show and talk about the wins for non-citizens. And I've really only got one of note. I'll talk about another case after, but Salguero Sosa out of the Ninth Circuit. I always like to talk about the Ninth Circuit on your show because you and I are both in the Ninth, and it's It's about past persecution. It's an interesting asylum case. The individual suffers from dwarfism, and he's an advocate for the rights of dwarfs in Guatemala. So definitely a unique case. And there's a whole bunch of reasons that he said he was harmed and he feared harm. And ultimately, the case got remanded back to the BIA and probably the immigration court. But the interesting reason for this, and I think it's really the Ninth Circuit that is at the tip of this spear, is that the decision reaffirms Ninth Circuit precedent that says for the persecution, for whether a non-citizen has suffered past persecution, the immigration judge needs to consider all harms cumulatively. And that is the law for a convention against torture. You have to consider all harms for torture cumulatively, and that's kind of because of some of the wording and the regulations for the Convention Against Torture. Not the same regs for asylum, but this is now the second or third Ninth Circuit case, and they're very clear in this case that even if, harms individually, separate harms, wouldn't rise to the level of persecution, you got to consider whether altogether it is. And if an immigration judge in the BIA fails to do that, at least in the Ninth Circuit, it's per se reversible error, it seems, and it's got to go back.
Damn.
It's something that I said on the podcast attorneys should be advocating for in all the circuits. It's certainly a non-citizen friendly standard. It seems intuitive to me. And so, check out, especially if you know the Ninth Circuit, remember Salguero Sosa, and that the cumulative harm standard is required. It's really a good gotcha to get to the BIA on appeal, and certainly the Ninth Circuit if you end up at that far of a level. Another good gotcha from the same case is another reiteration of what the Ninth has said, and that is the nexus standard. That is the reason that the non-citizen suffered harm. It's got to be on account of a protected ground for asylum. It's got to be one central reason. So, the fact his political opinion or his membership in a particular social group must be one central reason for the persecution Mr. Salguero Sosa suffered to get asylum. Fine. But for withholding of removal, which is actually a higher standard, you have to show that there's at least a 51% chance that you'll suffer harm. It's actually a lower nexus standard. It just has to be the political opinion or the social group. It just has to be a reason, one reason among many. And it's this wonky issue that there's a circuit split about because of the actual statutory text. And it's this weird situation we find ourselves in. So know your circuits when you're, if you get a loss on nexus, know your circuits, know the law, because that's also a per se reversible error. The Ninth and the Sixth, I want to say, have the different standards. The Fifth doesn't. Can't remember who else doesn't. The First Circuit has flirted with it. I said it on the podcast when I was talking about the case. I can't remember at this moment, but it's just one of those weird immigration wonky issues that's percolating out there. So Salguero Sosa, very clear on that again in the Ninth Circuit.
It's like, how do you write legislation and be able to get it perfect? Because it's so hard, because any word being the wrong spot on any statute could rearrange things. It's such a hard thing to do, especially nowadays where they write 1,700 page bills all of a sudden. It's so easy for the wording to go bad. But I mean, that creates our job and everything like that, situation. But just interesting how stuff could be debated.
I agree. I mean, but if you're, I think that judges kind of used to be more sympathetic to that, but we are in a text-based, statutory, constitutional text-based world of the Supreme Court now. I think it was Justice Kagan said, we're now all textualists. This is the world that the conservative and somewhat reactionary conservatives on the Supreme Court wanted. This is, and as Justice Gorsuch has now held 2 or 3 times, it benefits non-citizens too.
Yeah.
They are treating the text of the statutes and sometimes the Constitution like the word of God. So we, for better or for worse, we're in this textual world. And so while I'm certainly sympathetic that a 1,700 page bill statute is impossible not to have mistakes, that's the world that the Supreme Court has said we need to live in, and Congress has known that for quite some time. I mean, these text-based, but the withholding, when withholding was passed, asylum existed, I believe. and they did not use the exact same language that was already there for asylum. So like, that's on Congress.
Yeah.
Same thing we saw with 212H many years ago. It eventually was going throughout the circuits, and eventually the BIA came around in a matter of, I can't remember the name, but essentially you remain eligible for a 212H waiver even if you've been convicted of an aggravated felony, so long as your entry into the US wasn't as an LPR. So even though that makes no sense, but that's how the statute is written. You have to have entered as an LPR and then been convicted of an aggravated felony for you to be barred from a 212H waiver. If you adjusted in the US, you're pretty much eligible for a 212H, even with the ag fel, which makes no sense. But most of the circuit said, look, that's what the statute says. And finally, the BIA was forced to reverse itself and say, yes, that's what the statute says. Fine. I don't know what world we want to live in. I'm just saying, if whatever world it is, we got to all be playing by the same rules. And so this is the world we're living in.
Has some value in this kind of things. Well, real cool. What else is going on?
Well, that was the only notable win for non-citizens in December, tragically. Although, the circuits do shut down a bit in December. But Song v. Garland was an interesting one out of the Fourth Circuit. And it regards a published BIA decision, matter of Song. So that's always interesting. And it's about K-1 visas, which I know you deal with probably more than me. And there's very rarely decisions on K-1s.
Yeah.
And so I thought it was interesting. I thought you might want to talk about it. It's about the I-864 requirement to become a conditional LPR after entering as a K-1. In this case, Miss Song's marriage kind of disintegrated. Nobody's alleging marriage fraud, but her husband withdrew the I-864 after he filed it, before she adjusted to conditional permanent resident status. And eventually she gets a substitute sponsor. So like, she's got the sponsor, she's here, she's not going to become destitute, she's not going to become a burden on the US government. But the BIA, and then here in this case, the Fourth Circuit said, for K-1 conditional adjustment, it's got to be the petitioning spouse. There's no way around it. And that's, quite frankly, back to our discussion just now, it's based on the statute, said the Fourth Circuit.
I want to jump in for a quick second and talk about one of our wonderful new sponsors, ImmigrationEvaluationDirectory.com. Did you know research reports psychological evaluations can increase an asylum applicant's chance of approval by 78%? Psychological evaluations are hugely beneficial in hardship, cancellation, asylum, and other types of immigration cases, whether with USCIS or the Immigration Court. Connecting with qualified clinicians has never been easier thanks to the ImmigrationEvaluationDirectory.com. Free to use, you can filter the directory by location, language, case type, and more, then review profiles and reach out. The Immigration Evaluation Directory is your one-stop resource to find the best therapists to help. Explore more today at ImmigrationEvaluationDirectory.com and get the help that you need. Yeah, it's an interesting matter. I mean, someone had posted in one of the Facebook groups too. They actually know this. They got this case denied because they, K-1 comes in, doesn't marries the initial K-1 sponsor, or whatever, but they separate. You remarry a U.S. citizen, you can't adjust status. Or if that I-864 sponsor continues the sponsorship, you can, but they're probably not because they don't like each other. So they're gonna withdraw it unless you do like asylum. You got to go, and you're probably gonna be subject to a 3 or 10 year bar at that point too. So that situation.
I got to amend actually what I just said. This is actually the text of the regulation, not the statute itself. Similar thing, but the circuit doesn't defer really nearly as much to the agency when it's the plain text of the regulation. It's just determining whether the regulation is reasonable, or here whether the BIA was reasonable. So in this case, less, the DOJ, DHS could write new regulations. The Biden administration could say, this isn't right, we don't like that reg, take it away, and then you'd have a different decision. And the argument was made, as was made in the Facebook groups, as they're kind of saying, like you were referring to, is like, look, this puts a lot of power on the petitioning spouse, risks abuse, risks situations that are dangerous for the K-1 conditional, LPR applicant.
It puts them prisoner kind of. It's kind of it creates a valve potential situation on its own. Yeah.
But, the BIA did say in matter of song that there are exceptions for abuse and death, and that's a quote, pretty cryptic. But the BIA and the Fourth Circuit also said, I mean, this is interesting. I don't know how real world it is when you're thinking about, right, a foreigner coming to America, already pretty dependent on the non-citizen. But the quote is the BIA said, like, quote, a divorcing applicant could agree as a negotiated term in divorce not to sue the sponsor for breach of his contractual IA-64 obligations, which survive divorce. So, like, you'd have them like have any hand in divorce. But I do think most states allow for like no fault divorce, right? I mean,
Yeah.
I don't know I guess there can be suits a lot. I think that's a heavy price to ask for someone who by definition has just come to America because they're a K1, right? To say, all right, now you're getting divorced, negotiate them to sponsor you and that you're not going to sue them so you can become a conditional LPR. They could do that. It's a heavy ask. The Fourth is saying, well, look, the K1 is only here because they married a U.S. citizen.
Yeah.
So it's not so crazy to say they can only stay here if supported by the U.S. citizen. I guess reasonable minds could differ.
Interesting thing is, right when this came out, I got a consultation for a guy who got divorced, and he was calling about what the responsibilities of the I-64 are. And I told him, well, you can't get out of the government responsibility. That contract, the government's solid until the person naturalizes or yada yada, the 5 different things. But then we started digging deep in that language. I went and looked up when the statute or the regs were updated on this, and in the commentary they said that potentially you can negotiate to get out of a divorce out of the responsibility I-64 sponsorship from the person. But they said it in this haphazard, like offhand kind of way. But so if you are, in a case where you're dealing with a petitioner and they're divorcing, that's some advice in divorce. His lawyer hadn't told him about that. He got stuck with it. And he's like, am I going to pay I-64 sponsorship for the rest of my life? I'm like, if she doesn't naturalize,
Right.
yeah. Now, I was researching. There's one attorney in Seattle, Mick Lawson, I think, who's like the expert. He's the #1 guy for suing on these on the beneficiary applicant side. And his website was saying that a lot of state courts find it objectionable to have in perpetuity payments like that. So they'll in divorce proceedings, it's best to negotiate if you're going to do it. But it's kind of a weird situation. Let's say the sponsor was like a good guy, though. The foreign spouse gave him some crazy whack or something like that. Who knows? Being stuck in perpetuity if they don't naturalize is kind of a tough thing to have in there. So just an interesting thing that popped out of that situation.
Doesn't that create, though, another problem? Yeah, no, it seems like everyone is agreeing that that is a possibility, but doesn't that create another problem whereby then you have somebody without any sponsor in America, right? You're kind of getting around the IA-64 purpose.
Yeah.
You don't have to, the non-citizen doesn't have to have a substitute sponsor. I mean, there'd be no ground of removability, right? Based on your lack of sponsor once you are an LPR. So that is, unless I'm missing something, kind of a way to blow up the entire sponsor framework in American immigration law.
I mean, the part of the government stays there, so they get food stamps or benefits. But yeah, but the day-to-day money thing, yeah, they got it. So yeah, it doesn't.
Okay, the part for the government stays there, so you have to prevent them from going destitute.
Well, the government part is just the taxpayers, but the destitute part is still. I mean, they're not getting the support. Maybe they should make a timeline of like 5 or 10 years, and then that's it instead of perpetuity. Maybe that'll solve that situation. So it gives them some runway to figure it out, and then ends. Because just in general, like if you're a joint sponsor for somebody and you sign the I-64 and like, what if for the rest of your life you got to be on the hook for that? I mean, I have disclaimers I give to clients. Some law firms won't do I-64s. There's some local law firms here that say go get a separate attorney for a marriage adjustment, for example. I have to support. Or they won't do the paperwork for joint sponsors. They don't want to get involved in this. But the perpetuity aspect of it is kind of unconscionable. One or another, they should add they have the thing where if you work for 10 years and 40 quarters or blah, blah, blah. But what if they don't work 40 quarters? That's a lot of time. There should be some sort of end. That should actually something that needs to have an end to it. It's kind of crazy. It should be there, but it should at the same time have some sort of end to it.
Well, for K1s, you got to have the petitioning spouse be the sponsor, says the board, and now the Fourth Circuit says that that's A-OK. So
I think that's going to stick. Yeah, I mean, it's pretty Solid. So you got to know that that's a pretty solid way the K1s are going to work. Just another
Yeah.
reason not to do the K1 and try to go marriage if you can.
Right. No, it's serious. I don't know why anyone does the K. Well, I mean, if you want to marry in America, I suppose.
Yeah, I've had it where it was same-sex couples who couldn't get married because of like laws in foreign countries. I had some
It's a
people
good
were like, "Oh, we
reason.
want to have our wedding in the U.S. together, this and that," and all of them regret it. They're like, "Oh, I wish you just got married, got done with it." Because once they come and you got to file for adjustment status,
Right.
and it takes a year, some field offices, and it's like,
Right.
just get it done. Like, there's no
Right.
point of that.
And multiple times last year, I got I-765s approved pending adjustment after the green card was issued.
There you
Or
go.
I've gotten 6765s denied after the green card is issued based on USCIS saying the person's now a green card. It's like, guys,
Yeah.
this is supposed to be pending adjustment. It's been a year. You hadn't had employment authorization for a year. It's that's a whole nother conversation.
Another reason why the K1 is like not a good idea. Just get the LPR stats, come in and get it up and running.
Yeah.
I mean, it's there, and a lot of people sell that. So I mean, I go on tangents about the K1. I don't like it, but there's the idea that it's faster and stuff like that, which is like barely. It's like
Yeah.
it's not worth it for most cases. But I guess that's it for cases.
That's
Anything?
all I got.
Okay.
That's all I got. I'll have more next month. I
Okay,
promise.
sounds good. Sounds good. There's one topic that doesn't end, which is if you offer asylum when you have status and it's pending for years, and then you get an employer who wants to sponsor you, can you adjust status? And almost every field office is denying these, but now I'm getting an uptick of people saying my cousin got his approved. His lawyer's advertising. They say we're going to get these approved.
Is that the
I've
matter of
seen
LS
lots.
issue?
I'm sorry.
That's a matter of LS issue?
Okay, yeah.
Okay, matter of LK issue,
And
right?
in the USCIS, because I collect denial notices on this from field offices, they say we don't follow matter of LK, except randomly sometimes they just approve it without anything. So I mean, you guys are the center for these kind of major lawsuits. If something pops up, let me know because I just tell these people I can't do anything unless you sign a disclaimer saying I know it's going to get denied. They're like okay, not going to do it. But I saw an advertisement on Facebook, someone saying we do these, we get them approved, hire us, and I'm like, wow, you could advertise that like. I don't know. I've seen too many of these denials to be able to say that, yeah, I'll get them approved. But it's just that it's one of those TPS fact patterns we used to talk about where I'm like, Supreme Court has to make a decision and they totally screwed it. But then again, the administration is opening up second ways for it. But
It's I mean, the problem is just, and I might be wrong, and the dust hasn't settled yet. In fact, I'm on a panel on Patel next month, but like, it's possible that whole argument to challenge matter of LK and adjustment eligibility because they're not in status, right? That's the argument. That is now that there's no jurisdiction in district court to even bring such a challenge because the savings clause only applies to petitions for review, and Patel blew up questions of law. Patel blew up the other jurisdictional basis. And so it's possible that you could only challenge matter of LK now on petition for review in immigration court. An immigration court denied, have to go through the whole process, would be terrible. I'm not saying that don't bring the claim, and in fact, with the right case, we certainly would bring the claim. But there are weedy jurisdictional problems now because of Patel bringing an adjustment of status denial of any sort in district court.
About a year ago, one of our colleagues did sue on this. I don't know the procedural stuff because frankly, I don't understand it. But what happened is National Benefit Center denied it. They didn't get to the field office for asylum with employment-based pending. And a lot of these scenarios, either they get employment-based or they win the green card lottery. Those are the two scenarios that happen. This person was employment-based. And the district judge just deferred it. I didn't like the decision at all. They said, listen, let's see what happens with the asylum claim. If it's approved, then we'll approve the green card. If it's denied, then we deny the green card. It's like, well, if we're going to wait for the asylum to happen, then asylum's going to happen, and it doesn't matter at that point. We're trying to get it going now. So it's kind of a cop-out, in my opinion, that the way they decided that, but it was district judge. They didn't appeal it. But that's the last decision I've read. Not only know that as a listener sent it to me. Maybe this kind of district stuff's happening that we're not necessarily hearing about. Doesn't come out. But that's like the only thing. I don't know procedurally how it went down, but the benefit center denied. They didn't get the field office, and it's such a peculiar fact pattern.
To have a shameless plug for my boss, aka partner, Ira Kurzban. if there is a district court case that is favorable for an LK challenge, it is in his new book, which is being sent out as we speak.
2 volumes, right?
2 volumes, and you can get it on ALA, and I think online as well. You have to pay for it, and then you can do a control. I do control find all the time, like for LK, L-K, right? And then you'll find all the places in the book where it's discussed.
Interesting.
But
Good
it's
stuff.
2 volumes now. Ira's not happy about it.
Yeah, I was thinking the nice color on it, is it green or something like that? Or
It's blue. It's light blue now.
Very beautiful. It's always a fun thing as a source of joy for immigration lawyers. It's a weird thing. Like if other people see it, they're like, "Oh, we're so excited about this book. Like, why are you excited about this much?" You don't. It's like
You're all a bunch of nerds, is what everybody else says.
Well, good stuff. And as always, thanks for coming. You have your own podcast, Immigration Review, neck and neck with Immigration Lawyers Toolbox Magazine, the top podcast in the immigration space. You're doing great, wonderful stuff. And you had me on the show, and people reached out. You got some listeners. You have friends of mine who listen to your podcast but don't listen to my podcast, and they're like, "Oh, I heard you on this podcast. I didn't realize you had a podcast." I'm like, wait a minute, podcast right here. Like, you listen to his, not mine.
I'll take it. I'll take it.
So it's wonderful. Stay on the line a little bit after this, but thanks again. I'll catch up with you next month.
Sounds good, John. Bye.
Awesome.